Welcome to the Tech Law Podcast, where we explore legal issues affecting technology companies, from startups to the giants. If it's tech and it's legal, we talk about it here. The show is presented by Pillar Legal. We help tech leaders protect their companies so they can focus on innovation and growth. Today is Convertible Note Day. We have a video that was recorded at the Harvard Business School Alumni Angel Association Bootcamp. It's a great event, virtual, online, every year in the fall. If you happen to be an HBS alumni, I encourage you to check it out. We will have links to the event in the show note. Big shout out to Alexa McCullough, one of the organizers for the event, and she keeps inviting me back year after year to talk to folks. Thank you for that. You will see her in the intro to the video, as well as in the Q&A section. In this one, we do a deep dive into convertible notes, comparing them to other financial instruments for startups, including safes and priced rounds. And then we have a couple numerical examples that we work through for those pesky conversion terms. And I hope that it's useful for you. It's a bit longer than some of our videos, 29 minutes of presentation, and then 14 minutes of Q&A. But hopefully, if you want to learn about notes, this is a useful video. Thanks a bunch.
Welcome back, everyone. We are going to continue our walkthrough of term sheets now with convertible notes and Greg Pilarowski. I have to say that Greg is, hello, Greg. Now I can finally see you myself. Greg did our boot camp last year, and he did safes last year. And this year he decided he wanted to do convertible notes. So today, I'm so pleased to introduce you to Greg. He's an alum of Harvard Law School, and he's the founder of Pillar Legal, which is a boutique international law firm with offices in the San Francisco Bay Area and in Shanghai. And I'm not sure, do you also now have an office in San Diego? So he has extensive experience representing technology companies, venture capital firms, and startups. And prior to Pillar Legal, Greg was general counsel for Shanda, a leading online game company. And before that, he was with Sullivan and Cromwell, an American multinational law firm. On that note, I'm going to say, Greg, we're delighted to have you here, and we'll let you go with convertible notes.
All right. It's great to be back. Thanks a bunch for having me again, Alexa. I really appreciate that. We have 45 minutes and then some time for Q&A. What am I hoping to accomplish in those 45 minutes? One, I'd like to talk a little bit about where convertible notes fit in with the various options that investors have to get money into an early stage company. And then I'd like to talk about a couple of features of convertible notes, in particular the documents and what things it makes sense to pay attention to when you're looking at a convertible note document. In addition, we'll work through the mechanics of conversion, one conversion at a discount, one conversion at a valuation cap. That's the heart of the note, and some of the key details are buried in those conversion mechanisms. So you've had talks today, one on equity financing and one on safes. The convertible notes fit pretty much in between the two of those. So the equity financings, that involves a lot of paper, whether it's the NBCA forms, the Series Seed forms, the house forms of whatever law firm is involved, a lot more documents. And then, of course, you need a valuation. It's a priced round. So you put a value on the company, and that determines what you're paying for the stock. The safes, I'm a huge fan of safes for early stage companies because they're so short, they're so simple. Y Combinator, I think, did a great service to the industry when they came up with these standard documents. It's only 5 pages of substance, no maturity date, no interest. So a lot less documents, very fast. You don't even need a lawyer to do it, quite frankly. You're just filling out a couple numbers, the cap, the discount, and the amount of money that you're investing. Convertible note in between. The safe is very founder friendly because it doesn't have that maturity date. It doesn't have any interest. The convertible note does have a maturity date, does have interest on it, and it could also have security in the assets of the company. And then there's often so additional documents and a little bit more investor protections. One of the challenges with convertible notes is that there is not an industry accepted standardized document that everybody's using. So for the safes, that's a document that was produced by Y Combinator, and you can go to their website and see it. And if somebody serves up a safe, you can just run a compare version against it and see if there's been any changes and largely trust the document. For convertible notes, we don't have a standard out there like that. And this is one of the things that causes a friction point because you have to actually look at the document, see how the conversion mechanisms work, and whether that's aligning with your expectations. So for convertible notes, there's often two documents, sometimes three. One is the note itself. And that's the key document. It has all the conversion mechanisms in it. It has the principal and the interest. There's sometimes a note purchase agreement. That looks a lot like a stock purchase agreement. So that has representations and warranties, closing conditions. We've seen some folks who combine the note purchase agreement and the note to reduce the paper. And then in some instances, if more money is being raised, if it's a tougher market, sometimes we'll see security agreements. What the security agreement does is it puts the note holder in the position of a secured creditor as opposed to an unsecured creditor. And so if the company fails and you get into a bankruptcy or a dissolution situation, those secured creditors come first in line ahead of the unsecured creditors when receiving any remaining assets or the proceeds of the sales of any remaining assets. For a small note financing, you probably wouldn't have a security agreement, but for larger ones, you certainly would. Now, when I was reviewing for this presentation with Alexa, she pointed out to me that actually just in August, the Angel Capital Association has released a form convertible note that they are hoping will become a standard and will be accepted by folks in the industry. Before Alexa told me, I hadn't heard of it, so I don't think it's become a standard yet. But if it does, that might make convertible notes a little bit less friction worthy than they are today. Sometimes with convertible notes, folks use term sheets. With safes, you never do because there's just two numbers to fill out. For convertible notes, though, occasionally you'll see these. This term sheet sample that I have here is from Westlaw. They're one of the service providers for law firms that provide form agreements and other resources. In the term sheet, this is a short one. It just has the principal amount, interest rates, maturity date, and then how those conversion mechanisms work, including what's the discount and what's the valuation cap with the conversion mechanisms. Now, the heart of a convertible note is, of course, conversion. There's multiple different situations in which a note could convert into stock, convert into equity. The key one, the one that everybody's hoping for, though, is for that convertible note to convert into equity in the next qualified financing. Qualified financing is normally a defined term in the convertible note documents. And the critical component that you want to focus on in that qualified financing definition is it sets a minimum amount of money that needs to be raised for that qualified financing to force conversion. So in a qualified financing, you don't have a choice as a note holder. You automatically convert into whatever equity is issued in that financing. Why does that minimum number matter? Because you want the amount being raised to be enough so that whoever the lead investor in that round is is negotiating properly to get the right preferred stock rights in there for that conversion, because whatever that lead investor negotiates for, that's what you get too. And so if that qualified financing is $1, well, then the founder's mother can put in $1 and the founder's mother says, oh, well, let's just do common stock. And now you flip into common stock. Not good for the note holder. So your protection here really is focusing on that new money coming in has enough skin in the game that they'll do their job and negotiate to get standard preferred stock rights. One little detail to focus on is that qualified financing might include in the definition the amount that's raised on the convertible instruments. So if that happens, you've got to just do the math on that and say, okay, well, if we're raising 10 million on converts and then the qualified financing is, 10 million and $1, now we're back to the founder's mom negotiating the preferred stock terms again. Not a good situation. Conversion mechanism, the conversion notes, they normally have principal plus interest, a distinction from the SAFE, and then all that principal and interest will convert in the next equity financing into the stock that's issued at that time. The conversion price, so you take your principal and interest divided by whatever the conversion price is per share to get your number of shares. When you're figuring out that conversion price, there's two mechanisms. One is a discount, one is a valuation cap. That's similar to safes. The discount, it's a discount to whatever the price is in the qualified financing. The valuation cap, that's just a valuation cap for the whole company. Divide that by the pre-financing company capitalization, and that gets you your conversion price. In the safes in 2018, YC made a change and they split it out so that there's a discount safe and a valuation safe. And they got rid of the discount plus valuation cap safe. And you have to choose up front which one you're going to go with unless you modify the safe itself. For convertible notes, the more investor-friendly document, that tends to include both a discount and a valuation cap. And then which one you use to figure out that conversion price, it's just whichever one gives you the lower conversion price, gives you the more amount of stock, whichever one is better for the investor. So another plug for convertible notes, if you're the investor as opposed to the founder. One key thing I want to draw your attention to is this distinction between pre-money and post-money. Very simple concept. I know you've already talked about it today, but it can get a little bit nuanced in the context of a convertible note, which is why I want to raise it again. So, reviewing pre-money valuation for a company, that's what's the value of the company before the financing money goes in. So if it's 4 million pre-money valuation and the investment amount is $1 million, then that means that the investors are going to get 20%. So that's the pre-money of 4 million plus the million going in. So 1 divided by 5 there, we get to 20%. The post-money valuation, that's what's the value of the company after the money goes in. So if you've still got that 4 million number, but now it's post-money instead of pre-money, so that means it's 4 million after the million goes in. And so now it's 1 divided by 4 and you get 25%. So the difference between the pre-money and the post-money is important with respect to the valuation cap conversions for convertible notes. Now, this is in the SAFE context, no brainer, because right at the top of the document, it says post-money SAFE, or the one before 2018, it says pre-money valuation cap SAFE. So it's right up there. But on the convertible note, unfortunately, this concept is buried in the definitions. And so it might not be obvious to you whether you're looking at a pre-money valuation cap or a post-money valuation cap. And it's because the documents are not standardized, this is like the sand in the wheels that people actually have to go look at the definitions, figure out what it is to understand what the numbers are. So in deciding, is this a pre-money valuation cap or is this a post-money valuation cap? It's a question of company capitalization. So conversion price, when you're converting on the valuation cap, the conversion price is equal to that valuation cap divided by the company capitalization right before conversion. And then the question is, what's in the company capitalization definition and what's out of the company capitalization definition? So in pre-money and post-money, many things are in both. So all of the outstanding capital stock, all of the issued common stock, any issued preferred stock, if there is any, that's all in the company capitalization. All stock options, whether they're issued or whether they're reserved for issuance, that's in the company capitalization. Warrants, if there's any, that's in. Where the detail you got to focus on when you're looking at the convertible note is what about those convertible instruments? Are they in the definition or out of the definition? So if they're not in the definition, then your valuation cap is pre-money. If they're part of the definition, then you're in a post-money valuation cap. So that's a nuance that you want to focus on. What are common discounts and caps? The data that I've seen out there and just my own experience, 20% discount is pretty common in the documents. That's expressed as 80%, 0.8. So whatever the price is in the next round, you multiply by 0.8, you get your discount conversion price here. Valuation cap, you folks on the other side of the Charles River are better at this than me. This is generally decided by people before I even get to the table in terms of setting the valuation for the company. Valuation cap, of course, not the same exact thing as valuation in a priced round, but it can have the same effect. Now, I'd like to jump into a couple of conversion examples. Actually, before I do that, one other thing I wanted to point out is this pre-money versus post-money cap. Generally, as an investor, you think, oh, post-money is better, right? This has a protective effect for me against other convertible instruments being issued after I've bought my convertible instrument. Because if I've got a post-money cap, then any subsequent convertible instruments that the company issues doesn't dilute me. It only dilutes the founder. Sounds great from an investor's perspective. Let's go for the post-money cap. I think that's generally true just on the math. But what I have seen happen, though, in times is that the founders might not always understand that nuance. And so I've seen situations where founders are doing multiple rounds of financing on convertible instruments, whether it's safes or whether it's convertible notes, and not doing the math to see what their real dilution is. And so if you're in that kind of situation, I think it's reasonable to remind your founder to actually spreadsheet it out and see how much of the company that they're selling with each of these raises. Okay, into the details of a conversion. So I have two examples lined up for you. One is for a discount conversion. One is for a valuation cap conversion. Now recall, in the convertible note context, as opposed to the safe context, you'll generally have both the discount and the valuation cap in your note. So which conversion happens at that next qualified financing, it'll just be whatever's better for you, the investor, whichever one gives you more shares, whichever one gives you the lower conversion price. So in the discount conversion calculation, that conversion price, it's going to equal whatever is the price in the next equity financing, qualified equity financing, multiplied by the discount. I've tried to keep the numbers simple here because I'm a lawyer and we prefer simple numbers. So the cap table we've got on the left here, the founders have 900,000 shares. We've got 100,000 shares, 10% saved for the ESOP, a total of 1 million shares on the cap table before the conversion. The note holder invests $1 million. They've got a 20% discount expressed as 80%, 0.8 in the actual document. That can be a source of confusion. And then in the next equity financing round, the new investor, they're investing $10 million at a pre-money valuation of $50 million. So this is our hypo. How many shares does the note holder receive? So it'll be the number of shares. It's going to be that purchase amount, $1 million, divided by the conversion price. And then that conversion price, it's going to equal the price that the new investor is paying multiplied by 0.8, the discount. And then that new investor's price, that's going to be the pre-money valuation of the company. So that's $50 million divided by the company capitalization right before the equity financing. So this is going to be something for that new investor to negotiate. But generally speaking, that company capitalization right before the equity financing, that will include the number of shares that goes to the note holder. So we end up having, the X that we're solving for, the number of shares for the new note holder. That's on both sides of the equation here. You folks, I'm sure, could work that out with the spreadsheet. The rest of us in the law school, we're putting it into ChatGPT, and we get 25,641 shares for that new note holder on this on these numbers. The company capitalization prior to the equity financing, then that equals 1 million shares. What we had in that cap table, we're showing the 900,000 for the founders, the 100,000 for the ESAP, that 1 million shares plus the shares that go to the new note holder. So that's the 25,000 or so. The purchase price for the new investor, that's going to be the pre-money valuation. So that's at 50 million divided by the company capitalization right before the equity financing. And so that's the 1,025,641. That works out to $48.75 per share as the new investor purchase price. Now us, the note holder, we take that new investor purchase price, we multiply it by 0.8, and then we get our conversion price, which is $39. And then we take our $1 million investment, divide it by $39, and that gets us right back to our 25,641 shares. Down at the bottom of this slide is the cap table at 3 different slices in time. So the first one is the pre-note, pre-conversion cap table. So that's what you saw on the last slide. So 900,000 for the founder at 90%, the ESOP of 10%. That next moment in time is right after the conversion, but before the equity financing happens. And so here, that note holder is on the cap table, 25,641 shares, 2.5% of the company, founder down to 87.75% of the company. Next slice after the equity financing, and there we see the founder has now dropped down to 73. The new investor at 16%, and the note holder has dropped to 2%, a little over 2%. Let me pause there for a second. Are there any questions on this hypo that would be helpful to clarify now before moving on to the next hypo? This is the hard part for the lawyers, right? Whenever you're doing this, if the lawyers are doing your cap table, check the math. Always, always check the math. So the next hypo, this one is for the conversion on the valuation cap. So all the numbers here are the same, except we've got a post-money valuation cap of $20 million. And so we're converting onto that valuation cap. So here the conversion price, it's going to be equal to that valuation cap divided by the company capitalization. And in this hypo, we're doing a post-money conversion cap. So it's the company capitalization, including the shares that go to the note holder. Now, one of the things that's nice about this from a mathematical perspective is what percent you're going to get. So it's $1 million that's invested in the note, and then the post-money valuation cap is $20 million. So 1 divided by 20, you're going to get 5% of the company post-conversion, pre-equity financing. You're going to be at 5%. That makes our formula for the conversion a little bit easier, in the sense that the company capitalization right before the equity financing is going to equal that 1 million shares that we see on the cap table to the left, plus 5%. So plus the amount that's going to be issued on the conversion of the note based on the valuation cap. You work the math through on that. We do have a spreadsheet. I've given it to Alexa. If she sends out, I think she'll be sending out the slides to everybody. And so there'll be the spreadsheet as well. So you can see the math on these hypos, both in the slides and in Excel. This works out to a conversion price of $19 per share. And of course, that's equal to the 20 million valuation cap divided by the company capitalization right before the equity financing, which is this 1,052,000 shares. So the number of conversion shares here, the math works out to 52,632. So that's obviously more than what we would have gotten on the discount. So because it's the better of the two, in this hypo, we're going to be converting on the valuation cap as opposed to converting on the discount. Working through the rest of the numbers, the investor purchase price here, it'll be $47.50. So that's the 50 million divided by the company capitalization prior to the equity financing. Bigger number here, 1,052,632 shares. The new investor shares purchase amount, 10 million divided by their purchase price. And then down below, we have the same 3 moments in time cap table. What that cap table looks like pre-note conversion, what that cap table looks like post-note conversion, but before the equity financing. And there you see your 5%. So the 52,632 shares equals 5%, 1 million divided by 20 million, 5% right before the equity financing, post-conversion, pre-equity financing. After the equity financing, then a bit more dilution and the note holder down to 4.17%.
In the example, you were not including the interest rate, right?
Yes, you're right. And this is, once again, the handicap over there at that law school. You got it. I made the math a little bit simpler and we excluded the interest rate. But you're absolutely right. One of the things that drives the lawyers nuts is with the interest rate, of course, it accrues daily, right? So it just keeps moving. And when you're doing one of the conversions, folks will often pick a closing date and lock the interest rate so that all the math can be done in advance. So the heart of the convertible note is those conversion mechanisms in that next qualified equity financing. But the document does, of course, address other potential scenarios because you don't always have that qualified financing. So what the documents will also address is a non-qualified financing. So the qualified financing, remember that hits the threshold number and then it's a mandatory conversion. If there is a financing, but it's not hitting that threshold number, then the note holder will generally have the option. You can convert if you want to, or you can stay unconverted in the position of a note holder, of a debt holder. Maturity date conversions come up. This will also be optional. So the maturity date, sometimes 18 months, sometimes 2 years, negotiable, could be shorter, longer. At maturity date, of course, the loan is the convertible note, it needs to be repaid. In that situation, what often happens is folks, if they think the company has a future, they'll often negotiate an extension to the maturity date. I think the SAFE kind of recognizes the situation that if there isn't a convertible, if there isn't a financing happening in time, then the company often dies. But there's also, of course, the option to convert at any time if that made sense, although it generally does not. Other conversion events, liquidity event and dissolution event. Liquidity event is generally an M&A exit. So if the company is purchased before they do that first financing round, then this liquidity event tells you what happens. And normally the note holder would have the option. They could get repaid their principal and interest at that time, or they could convert into common at the valuation, depending on what the consideration is in that M&A exit. It could be cash, but of course it could be stock of a public company. It could be stock of a private company. So, various different scenarios, and the note holder gets a choice then. It also addresses IPOs, but that never happens. You don't normally get lawyers being lawyers. We cover it off right here. in the vast majority of startups, that's the situation. So this is a pretty common event as well. And here, the note holder, you are in the position of debt. So in a dissolution event where the company shuts down, you do have priority over the equity holders, over the stockholders to any remaining assets. And then if you have a security agreement in place and have done the UCC financing statements to perfect that security interest, then you'd be a secured creditor ahead of the unsecured creditor with your claims to any remaining assets, although there often is not any. Other terms that are addressed in the convertible notes, you'll see a section on events of defaults. The big one there, of course, is just not repaying the principal and interest at the time of maturity. The consequence of an event of default is accelerates repayment in the maturity date. Of course, it's already due, but there is often other events of default that are listed there, like if the company's bankrupt or if they've violated or breached. Sometimes you'll see breaches of reps and warranties as an event of default. And if an event of default is triggered, that accelerates the repayment. The note becomes due. You'll generally see information rights in the convertible note documents as well. That will often look similar to the information rights that you'll see in equity financing. So you could have quarterly financials, year-end financials, sometimes inspection rights, but sometimes those rights are a little bit more limited in notes than they are in equity financings. Often, also, there's participation rights. So in that next equity financing, there'll often be a right to purchase your pro rata share of those shares in that next equity financing. Sometimes you'll see the MFN as well, most favored nation clause, which would automatically give the note holder any more favorable terms that are issued under convertible notes after the time that you purchase your convertible notes. Now, this MFN clause, there's different ways to do this. From the investor's perspective, you'd like to be able to just cherry pick any more favorable clauses that come out in subsequent notes, whether that's a bigger discount or a lower valuation cap or a higher interest rate. The company's lawyers, they won't want that. They'll want it to be an all or nothing kind of deal where if there's a future convertible note that has different terms that you view are more favorable, then you might have to flip over into that new convertible note. As opposed to just cherry pick the better terms from that convertible note. So just a nuance that can come up in the MFN clause. Comparing the convertible notes one more time to everything else that you've already heard about today, compared to an equity financing, again, the convertible notes, that's a debt instrument, not equity. You can delay the valuation cap or the valuation discussion, sort of, but you kind of slips back in with that valuation cap number. You don't receive any stockholder rights, so no right to vote on stockholder issues. You don't receive any dividends. There never are any anyway. You don't receive any of those preferred stockholder rights, but upon conversion, of course, you will get those rights to the extent that your lead investor in that qualified financing round negotiates for them. Notes generally do require less time to negotiate, and they involve fewer documents than equity financing. So preferable in that sense. Compared to safes, they're a bit more messy because we don't have that standardized document yet, although we're all cheering for the Angel Investor Association to help establish a standard. And that requires somebody to look at the document to make sure there's nothing crazy in there. And so that adds a little bit of friction for convertible notes that you don't have with safes because it's a standard document. That said, with safes, you do need to check to make sure they're using the standard document. So the fastest way to do that is if somebody serves up a safe, go to the Y Combinator website, download the same form, run a compare version in Word, and you can see whether or not they've changed the document. Convertible notes generally more investor friendly though than safes. They have the maturity date, they have that interest rate. It is debt on the balance sheet. The safe is not, because the safe never needs to be repaid. The convertible note maybe does, and so that shows up as debt on the balance sheet. Notes, more documents, a little bit slower. compared to bank loans. Generally, bank loans aren't available for tech startups. They're pre-product, sometimes pre-revenue, generally very few material assets. And so loans from banks are generally not available. But loans from banks, of course, that's repaid with cash for both the principal and the interest. Convertible notes, though, in a good situation, doesn't get repaid and instead converts into equity. So a bit different there than a traditional loan. Pros and cons, key takeaway, convertible notes, better for the investor than the safe. Less work than an equity round. Cons, no standard template yet. Slower and higher costs than the safe. Two parting takeaway tips. I think some of this was also mentioned in the safe presentation. If you can encourage your founders to try to use consistent documentation along their convertible instruments, that can be helpful. We've had situations where there's inconsistent, sometimes safe, sometimes pre-money, sometimes post-money, sometimes convertible notes, different definitions of company capitalization. And it can lead to 20 different instruments with interlocking definitions so that you have to go out to Wolf Alpha because ChatGPT can't even do the calculation for it. And it gets to be a mess. And worse yet, it's the lawyers who are doing the math as opposed to the business people. So this can be a disaster. If you can encourage your founders to try to use consistent documentation, that's helpful. And then the other thing is with that post-money valuation cap, whether it's a safe or a convertible note, there is a trick in there that can surprise a founder. And that's that anti-dilution protection the note holders or the safe holders get against subsequent safes or subsequent notes. And the founder might not be modeling that out. So they might not see the implications of that. And that can lead to an unhappy founder, which at some point ultimately results in unhappy investors. I've got LinkedIn QR code down here. I encourage you to whip out that phone and pull up your camera and connect with me on LinkedIn. As I say, we're a boutique firm, so a little bit different from the big law firms that talked a little bit earlier today. I do think that big law firms, I used to be at one, have certain advantages, but I think that the boutique firms have some advantages as well, in particular for early stage companies. We do free consultations for anybody, so I'd be thrilled to make that pitch for little law as opposed to big law when anybody's willing to listen to it. So reach out if that's helpful.
The Tech Law Podcast is presented by Pillar Legal. For more information about tech, startup, and video game law, visit our website. Follow us on LinkedIn, Spotify, Apple Podcasts, or YouTube. Links are in the show notes. And now for the legal stuff. We are lawyers, after all. This podcast is for educational purposes only. The information presented in the show should not be construed as legal advice. And listening to the show does not establish an attorney-client relationship. In addition, the information presented has not been updated since the episode publication date. It may be required to be updated or customized for particular facts and circumstances. Any views expressed by guests are not necessarily the views of Pillar Legal. If you need help with any legal matter, be sure to consult an attorney. And if you don't have one, consider contacting us. This podcast episode may be considered attorney advertising under applicable law.